A very good evening. You're watching the India Development Debate. I'm Tamanna Inamdar, and it's the biggest kahani mein twist for corporate India that no one saw coming. Remember the big Cyrus Mistry Tata fight after Mr. Mistry's unceremonious exit in October 2016 as chairman of Tata Sons? Well, the allegations, leaked letters and a court case that followed saw the NCLT rule in favour of the board of Tata Sons' decision to remove Cyrus Mistry. Now, another court, the NCLAT, has effectively overturned that order today. It has reinstated Cyrus Mistry as chairman of Tata Sons, hence making N. Chandra's appointment illegal, though there is a 4-week pause on Mistry coming back to Bombay House if he so wishes to. The move to convert Tata Sons from a public to a private company has also been reversed. While this is a big relief to Cyrus Mistry, it's a blow to Tata Sons and in all likelihood will be challenged in the Supreme Court. Speaking to us today to help us try and understand the implications of this huge corporate story are Shailesh Haribhakti, Chairman of Haribhakti and Company LLB, Tushar Kapoor, Senior Legal Counsel, Dipali Gupta, author of Mistry versus Tata Sons, and of course Anil Singhvi of ICANN Investment Advisors, who's also joining us on the show this evening. Welcome to all of you and thank you for speaking with us today. I'm going to start with Dipali just to set the tone of how crucial this is and the story that you have followed so far as well, Dipali, in your book as well. Do you think that this marks another chapter in the fight?
Oh, absolutely, Tamanna. I think this marks a round 2 for Cyrus Mistry. As far as I think predictions were concerned, I don't think anyone was expecting such a landslide order in favor of Mr. Cyrus Mistry. But it was expected to be giving him some relief. Clearly not as like I said, a landslide in that sense. So yes, it marks a new chapter in this fight which goes on. It also marks a vindication for Cyrus Mistry, who has consistently been maintaining that he had never done anything wrong to be fired so unceremoniously. So yes, there is that, but also the order still leaves a lot of questions unanswered. For instance, the order only questions the methodology, not the outcome. So at this point, it isn't clear if the same action can still be taken if the warning is given of 15 days ahead of the board meeting and if the board still continues to hold power to be able to vote out a chairman.
Okay, interesting aspect there. Let me get Anil Singhvi's take. Anil Singhvi, how do you see this? Cyrus Mistry today has been very clear that this is a vindication of his stand more than anything else. So, I'm not so sure if he's so keen to go and sit in Bombay House again. He wanted to be proven right, and as far as he's concerned, he has. But do you think it will end here? Mr. Singhvi, can you hear me?
Is it for me?
Yeah. Yes, Mr. Singhvi.
Yeah, there are 2 points very clearly that when you look at both law and its practice. First of all, I think there was a great breach of corporate governance the way he was removed in the October board meeting. It was not even in the agenda of the board meeting, and he was removed unceremoniously and without giving any opportunity to him to defend his case. I mean, even if you have the murderers and the rapists, they are giving the chance to defend themselves. How can you not have, when you want to remove a director from the board, opportunity to be given to him to be heard, and then you decide on the matter? So the way this was done was completely with malified intentions. It was not an item on the agenda. So we all know that the way he was removed was not legal and also far away from corporate governance. The second issue is very clear that the executive chairman or chairmanship can be the matter of the board, but removal of a director, I mean, which was done so unceremoniously and done with the complete intention of humiliating Cyrus Mistry, was completely wrong. And I'm glad that this is both has been restored so beautifully well. In fact, if you read the last 2 paragraphs of the judgment, the judge was, or the NCLT member was very, very reluctant even to suspend the order. But he said for the smooth functioning of Tata Sons, they would agree on this, that for 4 weeks they suspend the judgment only for the part of not him being reinstated as the executive chairman. So Justice Mukhopadhyay reluctantly agreed on that, but he did not even agree on this that directorship of the Tata Sons should not be reinstated, and he said that it should be reinstated forthwith. So I salute this judgment completely. I think this is the first time I'm seeing that in India the judgment has reason to the state of saying that we are not even suspending the judgment and this has to be reinstated forthwith. So I think it's a very, very speaking order, an order which has taken almost about 6 months. It has been kept in abeyance, but with articulation he has given the judgment. So hats off to NCLAT to have come out so strongly and have given a verdict in favor of Cyrus. The second point which I have had is minority shareholders. In India today, we are debating on this matter for a very long period of time that what are the rights of the minority shareholders. The Companies Act has provided certain rights, but they have never been tested before. And I'm glad that this judgment will set tune for the minority shareholders' right. Both brothers put together own 18% in Tata Sons. They can't be dismissed like this. So I think this judgment will really set, and even if it goes to Supreme Court, I find it very difficult for Supreme Court to supersede this judgment completely. So they have to really put down the tone of what are the rights of the minority shareholders in this country.
Mr. Haribhakti, you want to come in on that? Some interesting points there made by Mr. Singhvi, especially on how it protects minority shareholders and vindicates Cyrus Mistry's position.
Yes, I think this is a very scathing, comprehensive judgment by the NCLAT, completely overturning the decision of the NCLT earlier. And I think it's a great redemption of the prestige and the honor of Mr. Cyrus Mistry. I think this judgment speaks very highly about his conduct and the fact that he had not deserved the treatment that he got at the hands of the board in his pretty sort of extreme way in which the dismissal had happened. So I think that's the first point I would like to make, and it's a great redemption. But it puts the entire functioning of the decision making in the group into a bit of a turmoil. It creates somewhat of a decision making black hole. How does the group continue to function for the 4 weeks that it might take for the court to take up the matter and then rule finally on what should be done? Also, the other grave uncertainty is about how will the leadership position get restored, what will happen at the time that a different decision might be taken as the Supreme Court hears the matter. And therefore, it has cast the entire matter into a bit of a uncertainty of the kind that I have never seen before. This is an unprecedented, completely new set of circumstances, and new law and new practices will be established on how decision making should be carried on, what should be the way that dismissals of executive chairman should be done, what kind of legal support will have to be taken to continue decision making, and a host of other issues will get established as we see the final outcome of this case.
Okay. Mr. Cooper, let me come to you and get your point of view as well. We've been speaking to a whole host of people, including legal luminaries, all through the day. And one concern that seems to come up is, where does that leave the decision of the majority of the board? Do you think a decision like this, a verdict like this, has far-reaching implications beyond just Tata Sons and this particular case?
No, I don't think that the judgment has in any manner impacted the decision-making powers of a board and the majority of directors on a board to take decisions. However, it does seem to reinforce the principles of corporate governance which ought to be followed by directors who ought to act independently, even if they are nominated directors, in the interests of the company. Now, the questions which arises, and I am not privy to the materials which the NCLAT looked at. However, it is very clear that from the materials placed before them, they felt that there was a delinquency on the part of the independent directors to exercise discretion in the matter in taking an appropriate decision. insofar as the key takeaway from this judgment is concerned, I believe that it is that the stance of Cyrus Mistry stands fully vindicated as to the fact that he was unfairly removed. I am not on the aspect of going into the legality or whether he was, whether the board was entitled to remove him, but certainly on the propriety of the manner in which he was removed, certainly was definitely questionable. He stands vindicated in his challenge to that decision. He stands vindicated in his challenge to the acts which he pointed out were not being taken in the best interests of corporate governance and of the company. Whether that material which he adduced would prove sufficient in the Supreme Court or not, that will of course be tested in the weeks and months to come. I don't believe that this decision is going to be over in 4 weeks' time. I believe that after 4 weeks' time, it will only mark the beginning of the end game, where the Supreme Court will conclude as to whether or not the findings of the NCLAT ought to be upheld or whether the NCLT was right in its views. Having said that, I do believe that the NCLAT was wholly right in striking down various observations which were made in the NCLT order, which I thought were unfairly scathing on Cyrus Mistry, and I think the NCLAT was fully justified in setting aside those observations.
The question is now what happens next? We're talking about this going to the Supreme Court. One point of view is that they will uphold what the NCLAT says, etc., etc. But does Cyrus Mistry want to come back as executive chairman of Tata Sons? Now, I was speaking with Arima Sundaram earlier in the day, who is a counsel for Cyrus Mistry, and of course, he can't speak on his behalf. But he did indicate that that was never the purpose, even when the NCLT order was challenged. It is not necessarily that Mr. Mistry wants to come back and run the show. He wants to be proven right. Mr. Singhvi, what is your sense? Are we going to actually see this converge into a change of guard at Bombay House?
I think my point is very limited, that Cyrus Mistry's, the way that he was removed, this reinstatement redeems his stature as Tata Sons chairman. Now it is up to him to decide whether he really wants to come as executive chairman or not. But this judgment definitely redeems his position, which he enjoyed, and there was no reason for the board to have dismissed him the way they dismissed him. So now it is up to Cyrus Mistry. It is not for the board to decide whether Cyrus Mistry really wants to be executive chairman or not. This judgment has given this mandate back to the board of Tata Sons that he should be restored the position which he was enjoying. Now, I don't think Cyrus is really the person. He has made it very clear. It was never the power of being the executive he was delivering on that. And I think full marks to be given to Cyrus that he never acted any point in time. He was such a removal. He did anything to really the position of Tata Sons. So I think it is up to Cyrus whether he wants to come as executive chairman. But having said this, I hope and pray that he comes back onto the board of Tata Sons, being the shareholder of 18% shares of Tata Sons. It really becomes now for the corporate governance and for the lawyers and for the Supreme Court to really honor this, that 18% shareholder should be there representing himself into the board of Tata Sons. So according to me, it's important that he's back into the board of Tata Sons. It is not so material whether he wants to really act as executive chairman or not.
All right. So what does that mean for Tata Sons? Now, if you just take a look at Tata Sons' statement and what they are saying today, they also go on to say it's in their statement, it's not clear as to how the NCLAT order seeks to overrule the decisions taken by shareholders of Tata Sons and listed Tata operating companies at validly constituted shareholding meetings. The NCLAT order appears to even go beyond the specific reliefs sought by the appellant. That's what Tata Sons says. Dipali, is that giving us a sense that, if this was a vindication of Cyrus Mistry, it's unlikely that Tata Sons is going to allow itself to be painted as the party that has aggrieved Cyrus Mistry and the party in the wrong either. They are going to pursue this as well.
Which may be true, Tamanna, but the order very clearly states that not only is Cyrus Mistry reinstated in Tata Sons, he is also to be reinstated in the ancillary companies, the operating companies. Now, if you recall, when the firing had happened, the board of Indian Hotels had stood up and said, please don't fire Cyrus Mistry from this board. We stand by the decisions that he's taken in the past. That this kind of and actually the order further details that independent directors are liable to opinions that they have formed earlier, criteria based on which they have taken decisions earlier, and that was the dilemma in most of the operating companies of all the independent directors. So you saw some sort of a scuffle happening at Indian Hotels, at Tata Chemicals, at Tata Steel. There was a back and forth that happened because there were independent directors who said, well, we've taken decisions for the last 4-5 years and we've supported Cyrus Mistry through all of those. So how do we then go back and say, no, now we're going to fire him? And eventually the sum and substance of that was, well, we can't keep you on anymore because the primary shareholder doesn't support you anymore. So it was the no confidence vote of Tata Sons that played a role in his being voted off the other boards. So the order does actually roll all of that back. And
finish your point, Dipali. Are you done?
Yeah, sorry. So the order yes, does actually roll all of that back, and therefore, yes, not just what Cyrus Mistry had asked for. Now, Cyrus Mistry has repeatedly stated that I do not want to become chairman again. First in his shareholder appeals that he sent out, then after that in the actual court filings that he submitted, he has said that I don't want to go back to being chairman, but what was done was not right. The order still does not entirely or clearly address whether minority shareholder rights were breached.
Okay. No, so that is a key takeaway. Because I want to understand what the impact is beyond what happens in Tata Sons. Let me come back to you, Mr. Cooper, on this point. Now, everyone seems to sort of agree that it's not like Cyrus Mistry wants to come back and take over the position he had before. He wanted to be vindicated. So that's done. But what are the implications ahead that you see panning out for Tata Sons and as a precedent as well? Even if he does come back as executive chairman, the fact is the majority of the board does not support him, which is why he was ousted so easily in the first place.
No, I fully agree with you that his coming back as an executive chairman would be a little untenable given the fact that he would lack the support of practically the entire board of Tata Sons. I don't think that he really wants to come back, and I think, as he has rightly expressed himself, that is not his desire. But if the NCLAT felt that his removal was wrongful, then I think the consequences would be that if the order of removal was wrongful, then the status quo ante had to be restored, which meant that he would be directed to be returned to his original position. I think Mr. Singhvi was right. I doubt that he will take up that position. I don't think he is interested in doing so. But the takeover on the minority rights, which you asked me, is to be found in an observation of the NCLAT, where it holds that going forward, the majority shareholders ought to take the minority block along with them in their decision-making process. Now, that is something which is very key and significant. And to your question as to what is the principle which it seeks to lay down in its judgment, is that the majority cannot ride roughshod over the minority, particularly because of its finding that in the instant case, the relationship between the SP group and the Tata group were that of partners. They did come to the conclusion that this was in some sense a quasi-partnership between the Shapoorji Pallonji group and the Tata group, and therefore they must work together in a spirit of common understanding, etc. Now, this is distinct from saying that all minorities must always be taken along with the majority, and the majority ought to carry the minority with them, because that militates against the principles of corporate democracy. So I don't think that the judgment seeks to lay down that the majority must always carry the minority shareholders along with them in their decision-making process. In the facts of this case, they found that there existed elements of a quasi-partnership, and perhaps in that context made this observation.
Mr. Adibakti, if you remember, the NCLAT also enabled this argument of Shapurji, Palunji group saying that, look, we have 18%. They enabled them to come forward with those arguments and recognize their share. Do you see this having any long-standing implications both for Tata Sons and for other cases of corporate governance, mainly when there is a very strong figurehead at the helm of affairs who doesn't want to let go? We've seen that in another stellar blue chip IT company in the last few years. And then this question comes in on, who runs the show? Broadly, do you think in a question like that, this judgment has implications?
No, I think this judgment lays down a lot of interesting principles. It lays down that the appointment of a chairman should be done with due process. And it finds very clearly in its judgment that the appointment was done through a very transparent, competitive process. Mr. Cyrus Mistry was virtually persuaded to take on the position. So therefore, the appointment was well done. It also, to my mind, lays down the principle that it is important to develop the moral capital, the trust, and the support of the entire board for a chairman to function effectively. And where that trust is not there, the way that it should happen opens up, to my mind, a potential for Mr. Mistry, who everybody seems to feel is not interested in reinstating himself, to take the high moral ground and take a decision on how he would like to proceed in the light of the positive way in which he has come out in terms of the way he conducted himself. And therefore, it might open up room in the next 4 weeks for there to be a discussion on how the way forward should be charted out. To my mind, it opens up that space of 4 weeks and more perhaps, during which the entire smooth functioning and the re-establishment of a leadership that can be trusted to take this fantastic group in our country forward in its march towards becoming even more sustainable and even more powerful in terms of the impact that it makes on our country. So I think it has opened up those kinds of possibilities, and it will be very interesting to see what happens outside the courtrooms,
Yes.
and also extremely important to await what the Supreme Court will finally give as its judgment.
In fact, so many theories doing the rounds today of what could happen in the next 4 weeks. Could we see Cyrus Mistry come back as non-executive chairman, but N. Chandra continue as executive chairman? Would they try to, offload some of their 18% stake? So a lot of theories out there. I had an opportunity to chat with Arima Sundaram today, Cyrus Mistry's counsel, and ask him some of those questions. Listen in.
You must realize that the reason this whole matter went to court stemmed from the unceremonious removal of Mr. Mistry without following the articles of the company, without following procedures. And the whole case, the thrust of the case was that Mr. Mistry had been insisting on proper corporate governance, insisting on transparency in management, and that the interest of all stakeholders should be looked after. And the company should be managed by a neutral board rather than run on the diktats of the trusts who are majority shareholders. Now, all this boiled down to oppression and mismanagement under the Companies Act, more so, as we pointed out, because the Tata Sons has such a substantial controlling interest in so many companies in which there's a huge amount of public shareholding and public money. And therefore, it was imperative that there must be a strict form of corporate governance. And this is what Mr. Mistry was trying to bring in when this immediate removal without following any of the procedures under the articles came about. That is why the case was filed. Now, pending the case, he was also sought to be removed as a director from all the other companies for having tried to set these matters right and for having brought this to the notice of the court. And not only that, they also tried to make Tata Sons, which is a public company, and as a public company under the Amended Companies Act, more having stricter corporate governance measures to follow, into a private company which would not have such measures to follow. Now, what the NCLAT has done, and I believe has vindicated the position of the minority shareholders, and in a way, it is not a victory for Mr. Mistry, but it is really an important step in ensuring proper corporate governance by one of the largest industrial groups, one of the largest industrial houses. And there should be proper corporate governance, which will be for the benefit of all stakeholders, howsoever small they are. And I think that is the big takeaway from this judgment.
All right. So that was Arima Sundaram talking about what it would mean for Cyrus Mistry. I want to thank all of our panelists on the big debate on IDD today. Shailesh Haribhakti, Anil Singhvi, of course, Mr. Cooper and Dipali. Thank you for joining us and putting into perspective. I don't think we've seen the last of it. Everyone's hoping for a happy ending in the next 4 weeks. But we'll see where it goes. We're on top of that story.